Hello, and I'm delighted to be joined this morning by Nigel Shepherd. Nigel's going to introduce himself because his list of job titles are numerous. Good morning, Nigel. How are you doing?
Morning, Tamsin. I'm very well. How are you?
Excellent. Yeah, I'm very well. Thank you. Really appreciate you joining us this morning. As I say, you have many hats that you've worn over the past and continue to wear. So I'll hand over to you for you to introduce yourself to our listeners today.
Yes, thanks, Tamsin. Yeah, I'm Nigel Shepherd. I'm a strategic advisor for Ampla Finance, and we'll go on and talk a little bit about what that does. I'm also a consultant and family law arbitrator with National Practice Mills and Reeve, based out of Manchester, but around the country. And those are my two, if you like, professional jobs. I have other hats that I wear. I'm still involved with the Family Justice Organisation Resolution in a more limited capacity than I have been in the past. I've been very heavily involved as national chair a couple of times and as a national committee member for practically 30 years, I think. So I've just stepped back from that. So I think they call it a portfolio career now.
Indeed, indeed. I think that means you can do lots of different things and not spend too much time doing one thing. So that's all good.
Exactly. Yeah.
So you're joining us today to talk about litigation finance and Ampla finance in particular. Our listeners may not know what litigation finance is. So can we start with that? Could you tell us a bit about what it is and how it works?
In very simple terms, it provides funding for people who are going through family law proceedings. So through your solicitors, who are partners with Ampla Finance, you can apply for a loan to cover your legal fees, which is then repaid out of the settlement that you get. And that's basically it. It's to help people who otherwise couldn't fund their case to get the representation they need and the quality advice that they need, often where their partner is able to fund it, but they're not. And it's about just sort of equality of representation to make sure that you get the advice you need to get a fair settlement.
Excellent. And how does the process work around if we start from the beginning? So going to see a solicitor and the solicitor says this is what it's going to cost you per hour, or this is roughly what it's going to cost you overall. How does the process then work around getting the litigation finance, applying, etc.?
Yeah, I mean, your family law solicitor is the first important part of the conversation that they have is, are you able to afford the advice? Because obviously that needs to be funded. If you can't, or you've got a limited amount of funds and that doesn't look like it's going to cover the whole cost of what's anticipated, one option is to borrow from somebody like Ampla Finance. The firm that you are with has to be partnered with the litigation funder, and that's just an arrangement which means that they have access to the systems. Your family law will talk to you about the process. An application will be made. You will be asked to have independent legal advice. Nearly all litigation funders ask you to get independent legal advice. With Ampla, that's done through a panel. If you want it, you can choose, and that's all set up independently from your solicitor. If the application is approved, and once you've had the financial advice, the loan goes live, and each time your solicitor bills you, which most firms will bill monthly during the course of a case. Our approach at Ampla is that you get notification of what that bill is. You can access it on your phone or your tablet or whatever. Once you've approved that and you've said that you're satisfied with the way it's going, that money then gets sent to your solicitor to pay that bill. And at the end of the case, when you receive your financial settlement, the loan is repaid. And that's how the process works. So it enables you, it takes the pressure off you. Obviously, it still has to be repaid, but it means that you can get the advice that you need. And it's really important because previously legal aid was available to people, but from about 2013, that effectively got scrapped in the majority of cases. Still get it if there's a domestic abuse element to your case. But for a lot of people, they simply haven't got access to the funds, and this is a way to make sure that they get the advice and have got the best chance of getting a fair settlement.
Yeah, absolutely. So would Ampla Finance, or I believe there are other litigation companies available. We should mention. I'm not actually on the BBC, but I suppose I should mention that. Are Ampla Finance looking and saying, well, we would expect there to be sufficient enough settlement to repay X amount? And is there a limit on the amount that Ampla Finance will lend based on what they would expect the settlement to potentially be?
Yes, I mean, the key thing is that Ampla will be relying and discussing with your lawyer what's involved in the case. Right. Absolutely right. The most important thing for us as a business is that we lend responsibly and fairly. We want to make sure that if you're borrowing through Ampla, you're able to repay it. And that's absolutely critical, because otherwise you'll be left with a debt that you can't repay, and that's not responsible lending from anybody. So yeah, we need to be clear on what the outcome is likely to be. Now, that's not precise. That's not a precise art. But generally speaking, we need the outcome to be sort of 30% what we call loan to value. Right. So if you're borrowing £30,000, we need to be looking at a settlement that's £100,000 or more.
Okay.
And the second limit of your question is there is no limit to what we can lend. We've got a lower limit for our business. That's not the same for all litigation funders, which is £10,000. There's no upper limit, and we have approved loans in very complex cases and long-running cases of over £1 million. And it could be higher. We're fortunate in the sense that we're backed by a private equity business, which means that access to funds isn't a problem for Ampla, as long as the criteria for the case are met. And it's important on that point that it has to be a UK family law case, or to be precise, an England and Wales family law case. And you need to be, as a borrower, you need to be UK resident and have certain residential criteria around that. So it's based in this jurisdiction. And there are other factors, but those are the key ones.
Okay. And as it's called litigation finance rather than divorce finance or dissolution of civil partnership finance, I'm assuming that there therefore needs to be an element of the court being involved, as opposed to it being an arbitration case or settled through mediation.
No, we call it litigation funding as a shorthand, but actually we can lend for any financial case, even in mediation or arbitration or through collaborative law. The key to it is there has to be what we call a route to repayment. So we have to see at the end of the day that the money is going to come in to enable you to repay your loan. The reality is, of course, that in arbitration, you get a decision, and it's going to be a binding decision subject to sort of fairly narrow grounds of appeal. In collaborative and mediation, it's about reaching your own agreement. And if you don't, and that process sadly breaks down, you will end up in court. So litigation funding is an overarching term, but no, we will lend on other kinds of processes. We will also lend on children proceedings if they're kind of running alongside the main financial thing. But of course, in children proceedings, there's no money coming in as a result of that. So there has to be a financial case primarily to enable the loan to be repaid.
Okay, so the loan can be used to pay the lawyers in the children bit, but you have to be able to see that there's going to be a financial settlement at the end of it.
Yeah, and generally speaking, the key part of the lending, the majority of the lending we'd usually want to see that for the finances. Okay. Just because that is where the repayment comes from. So yeah,
that makes sense. What was I going to ask you? Oh, I thought of a really good question then, and it's gone completely out of my head. What about, so I know if I go to a bank and borrow money to buy a car, for example, they're going to want repayments on a monthly basis. How does does litigation finance work from that perspective? Are there going to be monthly repayments as we go along?
The short answer is no. It is repaid at the end of the day out of the settlement.
Okay.
Obviously, the loan attracts interest. That interest rate varies through providers. Generally speaking, in the kind of market that we're in, you're talking sort of 14% to 18% for normal cases. More complex cases, you may find the funding, the interest rate's a little bit higher. The crucial thing is you only pay interest on what is actually drawn down on the loan. Okay. So if you settle your case after 3 months and you've only had 3 monthly bills from your solicitors, even though you might have asked for a facility of 50,000, if you've only used 15,000, you'll only pay interest on that.
Okay, that makes sense. And there's no monthly payments. The interest rolls up and you pay the whatever's owed, capital and interest all at the end.
That's right. I mean, providers do vary sometimes on how this works. So most have an arrangement fee at the beginning. The legal advice that's rolled up into the loan. The independent legal advice for us is the only thing that you as a borrower would be asked to pay yourself. With Ampla, that's a very competitive rate, £250 plus VAT if you choose one of our panel providers. And they take you through all of that and deal with that and then sign a certificate to say that you've had that advice before the loan goes live. That's the only bit that you pay up front, if you like. The rest is all part of the loan.
Yeah, and I guess that's important because you need to understand what you're committing to and what you're signing up to and what this is all about. Yes. What about, so we talked about the settlement being, the amount you borrow being around about 30% of what the settlement might be at the end as a maximum. What about if that settlement is all in pensions? I'm assuming that's not going to work for Ampla unless it's a case that the clients are already kind of over 55. Have I got that right? Or
yeah, that is right. I mean, it has to be realizable assets.
Yeah.
So you're quite right. If you can draw on the pension and you can take the lump sum out of the pension, that could be a route to repayment. We would want to be really responsible about that, though.
Yeah.
And the reality is that if it was purely pension is there, as you're very well known in your role as a top financial advisor in this field. The pension is there to provide for your retirement. And we would want to be absolutely clear, if you were using that to repay the loan, that wasn't going to leave you short later on in your life, because that would be irresponsible to lend. So generally speaking, we're looking at settlement of cash or investments, often a property that is going to be sold. So it's a realizable investment, really, that you can see where the route to repayment comes from.
It's a tricky job from Ampla's perspective of trying to juggle the settlement and what to lend, isn't it?
Yeah, as I say, it is about being fair, and our ultimate responsibility is to the person borrowing the money. We work with our partner law firms. We rely and discuss with them and trust them in terms of the advice that they're giving. My role as an advisor, part of that role, is to look at the more complex legal cases where there's trusts or there's a business, and we want to understand how the case is going to work and how the settlement is going to work in terms of of how the loan is going to be repaid. A lot of cases there is a property, it's property based. For example, it's the home that you live in with the partner that you're getting divorced from or separating from, and it's going to be sold. You know what the equity in it broadly is, and you know that there's enough coverage there to make sure the loan can be repaid.
Yeah, absolutely. Is there a point at which, because obviously you've agreed this is the most we're willing to lend, do you sometimes find that cases get kind of almost to conclusion but not quite there, and they've not borrowed enough to get them to the end point? How does that work?
That's a really good question, and something that Ampla Finance has that not all providers has is what we call a rolling account credit agreement. Now, what that means is, let's just say that on your 30% loan to value, we could lend you, or through your solicitors, £100,000 for the case.
Yeah.
But initially, you actually only want a facility of £50,000 because you think your lawyers think that's enough to get you through. So there's the headroom, if you like, will be 100, but you only get a facility at the outset of 50. If it turns out that that is not going to be enough because something unexpected happens or it takes longer, as long as we know that we could have done 100 at the beginning, we can then lend you more without having to rewrite the whole loan. And that's quite important because rewriting the loan, it's a new loan application, a new fee. That's how some providers work. We don't, because as long as we know that that headroom is there initially, we can increase it if need be, get over and above the original facility that you actually choose.
Okay, so like if I was going to buy a house and I went and got an agreement in principle, they tell you this is the maximum you can borrow, and you say, well, I'm only buying this house at the minute, so I need less than that, and then you do that, and then that house falls through, and you go for one that's more expensive. It's the same sort of thing. You're able to extend the borrowing to a higher amount.
It just means that you don't have to make a new application, and it's about underwriting in technical terms. The extension doesn't have to be re-underwritten, because we know that as long as nothing else has changed in the case, and we do ask our partner solicitor firms to keep us updated. We try and make sure we let them get on with the job because that's what they're there to do. For their clients, but we have a responsibility to check that things have not changed and that the original route to repayment hasn't become compromised. But apart from that, we trust our firms and we let them get on with it.
Absolutely. And the partner firms, did they give an indication initially as to how they, this must be really difficult to do, but how they anticipate the case going in terms of the length of time and the amount of money in legal fees that it's likely to require?
Yeah, I mean, a good family lawyer, all good family lawyers will budget and talk through that budget with you as the client. And that will be done at a very early stage. You scope it. It's not always possible, of course, to say exactly, you can't say exactly what's going to happen. But, you look at what's involved in the case. You look at the assets, you look at the way that you're going to try and negotiate a settlement of the process. Is it mediation? Is it collaborative? Is it arbitration? And you do a budget. And that budget will form the basis of the loan application that we will discuss. So the solicitors make an application. They can upload a spreadsheet with the assets on it. Very much that application, which is done through a portal. It's all done online through a portal. That application has a series of questions. It takes the solicitor 20 minutes to complete, but it will include values. And then our underwriters use that to assess, the loan to value and the route to repayment. And as I say, if it becomes complex, I might go onto a phone call or a Zoom call with the solicitor and say, just talk me through how you've seen the strategy on this, what's happening and where does that end up? So yeah, very much that conversation. That's the key part of the process.
That sounds very much like, even though there's a portal that they're uploading information onto, that it's not a computer saying no, it's a human the other side of it actually doing the underwriting and looking at the case.
Absolutely. We take the information, we assess it. We have our own internal processes to make sure that it's a heavily regulated sector, this, by the FCA.
Yep.
As you'll know, so we don't lend willy-nilly. This is a proper process, and as I say, it's about responsible and fair lending, and we want to make sure if we lend that it can be repaid, and we're not leaving people with a debt that they can't repay. So that process it's very mature, it's detailed, and then it goes to a loans committee that makes the decision. But we do try to push that through really quickly. So what we did as a business is that we wanted to try and make the process as stress-free for the solicitors as possible, because if they're spending time on the admin on it, that's something that is maybe passed on to the borrower, to the client, and what you want is the finance in place so you can get on with the job and get started with doing the important work. towards getting a fair settlement.
Yeah, absolutely. This might be this is a question I genuinely have absolutely no idea what the answer is, so I'm going to ask it. If a case needs expert input, so business valuations or a pension actuary, for example, can the litigation finance be used for paying those sorts of costs as well, or is that completely separate?
No, absolutely, absolutely. That will form part of the cost of the case. When we say legal fees, it's legal fees for your solicitor, but it's also what are known as disbursements. So it's also payment for independent experts. Absolutely critical. It's whatever it takes to get the case through to its conclusion and to get you a fair settlement. So yeah, absolutely. Accountants, pensions reports, property valuations, all key to anything that is involved in the running of the case throughout. Good
to know. Excellent. I like that. And is that I'm thinking about you've got one person who's perhaps needing litigation finance because they don't have the funds sat in a bank account to use, and you've got the other person who clearly, by the very fact that person A is using litigation finance, person B has accessible funds, or there's money somewhere available that will be there at the settlement of the fund. Is there any way of kind of balancing the legal fees on both sides so that the person requiring litigation finance doesn't end up having a considerably lower settlement because they've ended up having to use some of their settlement for repayment of the finance? Is that, am I living in dream world?
Yeah. No, I mean that's a really, really interesting question, which goes to the kind of case in a divorce case. So if we're talking about finances on divorce, they broadly fall into two kinds of cases. A case that's based on the principle of sharing, and a case that's based on the principle of needs. So sharing cases where there's more than enough money to go around, and the principle at starting point, if you like, is that the assets that have been built up during the marriage are shared equally. If it's that kind of case, then those assets will be after debts have been repaid. So when you're doing an asset schedule, your solicitor will draw up the asset schedule. You'll have a look at the assets on the one hand, and you have a look at the debts or liabilities on the other. And borrowing for your legal costs will be a liability that you would expect to be taken off the balance sheet before you get to a net figure, which is then shared.
Okay. Good news.
In a needs case, and there may be good reasons for this. For example, where a lot of the money in the marriage has been inherited or gifted, or other sort of quite complex reasons where you're looking actually at a settlement which meets the needs of the person that's making the application for housing, for maintenance. That maintenance may be paid off by an additional cash payment on top of the housing need. Even then, you would expect borrowing to be repaid before the needs are met, because otherwise you'd be eating into the sum that has been assessed as being needed for your needs. And that would be the same whether or not you owed the money to your solicitors at the end of the day rather than to an independent third-party provider like Ampla, or whether you owed it to your parents or a bank. But having said that, if you borrow from family, there's always a risk that the court will think that's not what we call a hard debt, and maybe they'll let you off it.
And that's actually a soft loan thing, isn't it?
It's a soft loan. Even if you have, let's just say you borrow the money from your parents, and there's a document in place that says you have to repay. If push comes to shove, there's always a risk that if something needs to give, it might be that gives, because they're going to think, well, your parents aren't going to sue you for the money if you don't pay it. And actually, we find ourselves lending to people whose parents might be prepared to lend the money, but actually they want to be sure that this will be treated as a proper commercial loan that is clearly repayable, and so you don't have that risk.
Absolutely. You want to kind of avoid your parents borrowing to lend the money in those circumstances, don't you? Because you would be better off borrowing the money yourself rather than them borrowing it.
Yeah, I mean, obviously, you wouldn't expect your parents to charge you a commercial rate of interest. So, your family lawyer will talk through the funding options.
Sure.
We don't see litigation funding as sort of borrowing of last resort, but quite clearly, if you can get access to money without having to pay interest, you're going to look at it seriously. But it's not just whether or not that debt might be treated as properly repayable. In my practice as a family lawyer over the years, I've seen a number of cases where people have been funded by their parents, but actually the parents then feel that that gives them a right to become much more involved in the running of the case than you, as the person getting divorced, would be comfortable with. And right. so it does. Getting an independent loan can buy you that distance and objectivity that can compromised by borrowing from family.
Sure, absolutely. So we've talked about the options of, I know obviously you're here to talk about the litigation finance, but we've talked about borrowing from family, having the money obviously available yourself directly. What are there any other options if you're divorcing somebody who has access to money?
Yes. The short answer is that if you can't get the money from anywhere else, you can make an application to the court for what's called a sort of litigation funding order. And that is an order which means that the other person in the divorce actually funds your legal fees. Now, one of the key criteria for being able to get an order from the court is that you've tried to get that borrowing from an independent source. And generally speaking, you have to get sort of 2 rejection letters from somebody like Ampla and another litigation funder to be able to say to the court, I've tried to get the money from somewhere else, I can't, and therefore I really need my spouse to fund this for me. And the court order around that has various rules around it. It certainly is very heavily budgeted normally. It'll often only take you up to a certain stage in the proceedings, and then you have to come back and ask for more. But that is the other option if the ability of your spouse is there to pay it.
Is that an option if your finance from your litigation finance runs out and there isn't that extra space?
Yes. So if you're able to fund it up to a certain point, but then you can't continue, at that point you can make a legal services order application.
Wow. Okay. Have I not covered anything that I should have covered? Are there any aspects of litigation finance that I should have asked you that I haven't?
I think that just one other thing is that if the loan to value, the headroom, if you like, between the settlement and what you're borrowing is there, Ampla and some other providers will also be able, in the right kind of case, to lend what we call a maintenance loan element. So, for example, in addition to your legal fees, if you've got school fees to pay for or something else, something essential to pay for, you can borrow that as well. But that's after the legal fees. So if there's only enough to cover the legal fees, you can't use it for anything else. The critical thing is that you're able to pay your legal fees and get the advice that you need. So that maintenance loan is an option. It doesn't get used that often, but it is there and can be lent.
Useful to know that it's there. That's an added bonus, isn't it? And Ampla Finance lend in other ways other than just in family proceedings as well, I believe.
Yeah, we have another key product, which is called our legacy product, which has 2 limbs. It's first of all available to executors of estates when somebody's died, who have to pay the tax before the money has come in from the assets in the estate. So it's effectively a bridge loan for that. And we also have a beneficiary loan. So if you're the beneficiary of an estate and you are, for example, due to receive proceeds from the sale of the house, but you want to access cash before the house is sold, we'll lend on that as well. And we're also developing other products in other fields. So Ampla as a business is not just about family, it's about funding in various cases that my particular my particular day-to-day role is primarily focused on the family, which is why I'm talking about it on your divorce podcast.
Absolutely, and obviously is the reason that we asked you to come and talk to us today, because there's, how am I going to pay for my legal fees is often a problem, certainly amongst the clients that I tend to work with, who tend to be the person who hasn't looked after the money, and so their spouse may well be absolutely fine in paying their lawyers and barristers and getting all sorts of people involved, and my clients are sitting scratching their heads wondering how on earth they move forward. I suppose one other question is, we talked about this finance being available for clients going through mediation, but we've also talked about it being available through family lawyers rather than through mediators. Is it available through mediators, or does it tend to be arranged by family lawyers who are also mediators?
It has to be arranged through a firm of solicitors. Now,
right.
if your mediator is mediating as a family lawyer within a firm, then it would be available.
Okay.
But our partner agreement, if you like, is with firms, and they're firms that we trust and understand, because we've got, the important thing is we have to understand how the case is going to work. Sure. But the solicitor's point of view, there's no recourse on them. So if you as a borrower end up for some reason unexpectedly not being able to repay the loan, we can't come after the solicitors for it. So it's very important. Sure. That's why it's so important that our primary focus is on responsible lending, and lending in the right circumstances for the right cases. And then our relationship with our partner firms is crucial to that, and important to that. But at the end of the day, the primary responsibility is you as the borrower, if you like, the client.
Of course. So if you are considering mediation, or you like to work through things through mediation, I guess it's go and see a family lawyer first and talk about the options in terms of funding the case, and then perhaps see a mediator following that.
I think in practical terms, mediation is a voluntary process. Collaborative practice is a voluntary process. Absolutely. In the vast majority of those cases, you'd expect how that mediation or that collaborative process is to be funded, to be part of the initial agreement before you go into it. So Sure. It would be quite unusual to have to use those funds for that. Arbitration is different, because arbitration gets you a decision. It isn't about you agreeing. It's a decision from an arbitrator as an independent private judge, if you like. And that's equivalent to being in court. It's just that you're in arbitration instead of being in court. Much better process, much more dignified, lots of pluses to it. But it's different in that respect to collaborative and mediation. And there's an outcome and a binding outcome to it. But as I say, collaborative mediation, you'd expect how it's to be paid for to be part of the agreement before you enter into it. So I don't think actually we have lent on one. It's just that we can do if it's needed.
You could. Yeah, absolutely. If anybody wants any further information about arbitration, there's a podcast in series 1 with Reece Taylor having a conversation about arbitration if you do want any further information on that. Nigel, I've come to the end of my questions. Have I covered everything?
I think you have. It's been quite comprehensive. It's been a pleasure to talk through it. As I say, litigation funding is a really, really important option to make sure that people can get proper advice and actually get a fair settlement. The last thing you want when you've got the stress of a separation or a divorce, you're trying to get through all of this. The last thing you want is the added stress of simply not being able to pay for fees. And that's what litigation funding gives you the peace of mind to do.
Yeah, no, you're absolutely right. And it's good to hear about the option that's available and how it works, because as with all of these things, there are always tales and rumours about how they work. So it's good to hear it directly from yourself on that. So massively appreciate you joining us today, Nigel. Pleasure. Thank you so much. Thanks, and we will be back in a couple of weeks' time. So thank you for joining us, and I hope you found that useful.
Thank you.